Welcome to all of you that are here today. My name is Chris Martinez. I'm General Counsel at the Justice Administrative Commission, also known as JAC, and together with my colleague, Alicia Davis, who will be doing most of the heavy lifting today, we're going to give to you an overview of who the Justice Administrative Commission is and how we can better serve you so that you can get the court-appointed work that you receive, you can get compensated for it. But a little bit of history about JAC, I think, will help clarify some very popular misunderstandings. The presentation will cover who we are, how to bill, how due process vendors can bill, and by that I mean the service vendors that you hire to defend your cases, the court reporters, interpreters, investigators, and expert witnesses, and also a special section on pro bono attorneys' ability to access state-funded due process costs in the Pro Bono Matters Act, which was the act that was just recently passed to give pro bono attorneys representing dependent children with special needs access to state-funded due process costs so they wouldn't have to foot those bills themselves. All right? Who is JAC? JAC was set up in 1965, right after Gideon versus Wainwright. And initially we were set up as a state office to administratively serve the offices of the public defenders and the state attorneys. Over time, since 1965, we've added some other offices that we serve, as well as gotten other offices have gone elsewhere. So now we serve the 20 state attorneys, the 20 public defenders, the Regional Conflict Counsel, 5 offices there, 3 offices of Capital Collateral Counsel, and the statewide Office of the Guardian ad litem. So together, all 49 different offices that seek justice, whether they are defending or prosecuting in court. Now, when we say we administratively serve these offices, what do? Well, we help them with their accounting, with their budget, with financial services, and also with human resources support. Although we serve all these offices, we do not supervise, direct, or control any of them, all right? So we just provide services, and we do that statutorily. We're the 3rd largest bill processing entity in the state. We do over 500,000 financial transactions every single year. Of those 500,000, 68,000 are the review and audit of court-appointed attorney fee and court-appointed due process service vendor bills, all right? We try to be very careful because the money that we receive from the legislature to process and pay these bills comes from you, the state taxpayers. So our goal is to be good stewards of your money, to ensure that the funds that we receive that are appropriated to us by the legislature actually go for the purposes that they're given to us. The commission. The commission is our guiding body. The commission is composed of 2 state attorneys chosen by the Florida Prosecuting Attorneys Association and 2 public defenders chosen by the Florida Public Defenders Association, and you have them listed here. Our state attorneys are Brad King from the 5th and Brian Haas from the 10th, and our public defenders are Diamond Liddy from the 19th and Kathleen Smith. The commission meets at least twice a year, and basically the purpose of the meeting is to update the commission on where the funding is, what the issues are, if there's any pending litigation, if any new law passed by the legislature is affecting JAC, and also for the commission to advise the staff on how they wish the business of the Justice Administrative Commission should proceed. A few things to know about JAC. About 6 years ago, we endeavored and we wrote a strategic plan. We did this to answer we started surveying our court-appointed attorneys and due process service vendors, as well as the offices that we serve, and we found that there was some dissatisfaction. So together with those surveys, we wrote a strategic plan, and our goal is to be a model of exemplary state government. We're not competing with other state government agencies. We're trying to compete with the private sector. So with 85 people, we perform all those financial transactions, and the way we do that is by training our staff a lot and by leveraging technology as much as we can. Our mission is to support the entities and the customers that we serve with fiscal controls, best practices, and exemplary service. Here we have our values and what we believe are our core competencies: administrative service, communication, collaboration, prompt payment, fiscal accountability, and continuous improvement and innovation. If you've been doing business with JAC in the last 5 years, I'm hopeful that you've seen this with our online bill submission system that we built back in 2011, 2012, followed up by online billing, and we are trying our best to stay abreast with technological developments to make your timekeeping and your submission of bills to us easier and more user-friendly. I went over the history. I already did most of this, but just so you know, our task with auditing and paying for court-appointed attorneys and due process vendors came to us back in 2004. I don't know if you remember, but back in 1998, Florida citizens voted in favor of Revision 7. Revision 7 brought the funding responsibility for court-appointed counsel from the local counties to the state. That illustrious task was given to JAC, and it was done 67 different ways throughout the state, one for each county. So over time, JAC has tried to do its best to streamline that process without creating a giant wrench into the judicial system. That was the circuit judge's biggest concern, was that our payment process not gum up the wheels of justice at the local level, and that's what we endeavor to do. Two things to know. We are a statutory entity, and who cares? Well, the reason I say this is because we only have as much power as the legislature gives us. We only have discretion to do certain things, and we have no discretion to do other things. Attorneys that choose to bill us hourly, there has to be an evidentiary hearing. It provides so in statute. So why does JAC always object when I bill hourly? Because we're statutorily required to, because it triggers an evidentiary hearing. And we appear at about 1,100 hearings a year, and we're based out of Tallahassee. That's why we do so telephonically. Some judges refer to us as the lawyers on the phone or the lawyers on the box. And, but of all those 1,100 hearings, they're not all for attorney's fees. Sometimes it's for due process services being requested in a case that are above the normal fee. All right? And another good thing to know is that the rates that you receive if you bill a flat fee bill to us, and the flat fee is determined by the highest charge on the charging document or the type of case that you're defending. Those are set by the legislature, not JAC. So, and we do not have any say in that matter. So please know that, and you may want to direct your concern about that to the legislature and not to us, because truly what we do every year is based on what we spent last year in court-appointed counsel. We grow it about 3 to 4%, and we project that, and that's what we ask the legislature for, based on what happened last year. Now, if like this year, there's a great influx of death penalty cases that were on hold while Hearst was being litigated, or if we see an increase in the indigent for cost line of business, then we alert the legislature quarterly, and we start doing what we call straight line projections, which is just a projection based on what expenditures have been. You take the average projection and you count that out for the rest of the year, and we do straight line projections for the legislature to try to predict if we're going to need more money. And we pester them consistently throughout the year. All right, so if you want to become a court-appointed attorney, what do you do? All right, the first thing you do is you contact us and you register for a My JAC account. So you send an email to contracts@justiceadmin.org, and you ask for a username and a password. And then you'll be provided a link so that you can set up your account, all right? Once you're on that account, you have the ability to execute a registry contract, or if you need to do a capital collateral registry contract, you could do one of those, but I doubt this person's here would be interested in that. And the third thing you do is that you apply in the circuit that you wish to be on the registry, you apply to their registry contact, not contract, to get on their circuits. Now, as you all know, there's 20 judicial circuits in the state of Florida, and the process for applying to circuit registries differs from circuit to circuit. We have a list on JAC's website with all the current circuit registry contact persons on it so that you can contact them if you so wish. This is our goal. Worry-free bill, worry-free billing. Sign up today. So, one thing that we're implementing this year, we've already implemented in practice. You will see it in the contract, the new contract, fiscal year contract, which will come out in mid-June. When you sign up for a registry contract, you have to do that every single year. The contracts run for a fiscal year from July 1st through June 30th, all right? That contract will allow you to be appointed to cases during that fiscal year. The next fiscal year, a new JAC court-appointed contract will come out. This year we're introducing this in order to prevent identity theft and cybersecurity threats. Since we're doing so much of our business over the internet, we are requiring all our attorneys and our due process service providers to register with an FEIN, a Federal Employer Identification Number, rather than use their Social Security number. That is one less bit of confidential information of yours that will be on a potentially public record, right? And you can apply for an FEIN online for free. And there's a link on our website to it. Do not be lulled. When you search it on Google, you'll get lots of hits, okay? But at some point, you'll say, pay your $250 now. Now, why would you want to pay $250 for something you could do? I did it myself. It took me 7 minutes. Even when the federal government was shut down, it took me 7 minutes to get my FEIN, and it was absolutely free. So I encourage you to do the same. Once you get an FEIN, if you have or if you don't have, you need a substitute W-9. That is a form required by Florida's Department of Financial Services. So if you had a substitute W-9 before under your social, you've got to get a new one under your FEIN. And if you didn't have a substitute W-9 before, then you have to apply for one when you sign our contract, okay? Because there's a portion of our contract towards the end where you have to certify that you have already started that process with the Department of Financial Services. Here's a screenshot of how to register. And here is a box for first-time attorneys. And there's where you put your bar ID. And all the way to the left of your screen, outlined in red, is where you begin your registry contract. Now remember, that registry contract does not become effective until you are on a circuit registry and until you are appointed to a court-appointed case. All right? Because it is not a contract for employment, it is truly just a third-party contract for payment. It is 26 pages long. I encourage you to read it. It outlines a lot of the things that JAC must abide by in order to process your bills. Getting that done up front and understanding it up front will only ensure a much smoother payment process for you, all right? And if you have any questions, we have a JAC help desk, which will soon be called JAC Online Support, and they will answer them for you. We truly try to ensure that all the provisions in the contract are required by law, by the Department of Financial Services, by the Department of Management Services, so that way it is, because you're really navigating a very complex system which is called the state bureaucracy. So you must have a current contract. They're issued every year. If you are on a registry right now, you should have you should have a current contract, which will run through June 30th of this year. Next year's contract will be published in mid to late June, all right? In order to avoid confusion of people signing contracts today and then wondering in August, what do you mean I don't have a contract? I signed one in May. The contract system will be taken down on June 3rd. So that the new contracts can be uploaded, all right? So if you're on a registry somewhere, you should already have a contract. If you're planning on getting on the registry for the next fiscal year, and just so you know, the circuits do their registries. They can amend or alter their registries throughout the year, but they do their big push in June, all right? So if you're thinking about that, get on the registry and sign the new contract for next year. Does anyone have a question?
So are the W-9s on your side, or we did those from the IRS?
That's a great question.
Tax ID number.
I'm sorry, could you repeat that?
Did you put our new employer tax ID number on there? Do y'all have the W-9s on your side, or do they get those from the IRS?
The question is, are the W-9s from JAC or are they from the Department of Financial Services? They're from the Department of Financial Services, and you can find the 1-800 number for that section at DFS on our website, and also there's also a link to it. But you have to certify on your JAC contract that you've already begun that process. JAC doesn't control DFS, and sometimes DFS can take a little bit longer, so the best that we could do is ask you that you've already started that process over with DFS, which is consistent with the FEIN number you're using on our contract, because it's all got to match. If it doesn't match, what will happen is that way over here, when it's time to get paid, and we upload your information into FLAIR, which is Florida's accounting resource system. I know the letters really don't match, but soon it'll be Palm. Over here, there'll be a problem if the name and the number and the address don't match exactly. So you have to be if you're not detail-oriented, get someone in your office who is, all right, and make sure. And even little strange things like commas, periods, junior, the third, things trip it up. So they have to match, they have to be precisely matched. Yes?
I'm on the registry, but you said earlier that you can bill, or you said something about after an evidentiary hearing. But I can't find any list of, say, if the case was closed a year and it reopens, you can bill for your time. Or if there's some structure, because I know if you're appointed on new dependency after this petition on a adjudicatory hearing, you can bill because of an evidentiary hearing. But as far as the other cases, is there somewhere online, or do you have anything that shows where else we can bill?
I think that varies. If it's a dependent child with special needs does it, I believe, one way, and in strict dependency cases does it another, and the best person to answer that is standing right behind me, Miss Davis.
Repeat your question.
I do this.
Okay.
The question is, when can we actually bill? Because
Okay.
there are kind of cases, ones that are reopened
Okay.
after a year, and
Okay.
just regular dependency and TPR are different. But if we just have an adjudication, that's an evidentiary hearing. But she said you can go after an evidentiary hearing.
Okay. And I'm going to go on in my presentation. What she's referring to in terms of an evidentiary hearing is if you're hourly billing. So most attorneys, about 96% of the bills we get are flat fee. So if you want to bill hourly, you are exceeding the flat fee set by the legislature, you have to do an evidentiary hearing. That's the evidentiary hearing she's referring to. No. Not in the life of a dependency case. We're just talking billing. So let's say you have a dependency case, you do the adjudication. At that point, you would send us the order of adjudication. You will bill your first year $800. Every year after that is $200. You don't need an evidentiary hearing to bill flat fee. Statute allows us to pay those administratively. Now, let's say you have a case that is special needs, a child with certain special needs. You know those cases are very time consuming. There's many hearings. It may take a lot of hours, a lot of time. If you decide, okay, the flat fee of $1,000 is just not sufficient for my time and effort in this case, I'm gonna bill hourly. In order to do that, you have to follow certain steps by statute. So that means you have to keep records, you have to keep your time, you have to bill it in tenths. And so when you are ready to bill, let's say the bill is $6,000, of course that's way over the flat fee, you have to set a hearing before the designated judge in your circuit. That's an evidentiary hearing in that regard, not so much an evidentiary hearing that we have in dependency cases. Does that answer the question?
So it does, but if, say I get a case that's reopened.
Okay.
And it's already been paid for the dependency, there's time that has to be closed a year?
Yes, it is a year. If it's closed less than a year, then you would get, if you're the same attorney that was appointed when it closed, then the fee would be $200. If it's over a year, then it'll be $800. So if you are the same attorney that was appointed when it closed, then it would be, you would treat it as a new case, a new appointment. If you're not the attorney that was the original attorney. Well, if it's under a year, it's $200. If it's over a year, it's $800.
And that's, if there's a structure anywhere, there are a bunch of weird things that happen, but if there's a chart anywhere, I would really appreciate it.
Okay, thank you. I don't know if we have a chart posted on our website. However, I will work on that. So thank you. I will work on that. Thank you.
And for those of you who don't know, Alicia, Ms. Davis, was an assistant general counsel at JAC for over a year, and she has just recently become the director of the court-appointed auditing section. All right, so you get the benefit of having one of JAC's assistant general counsels now working directly with the auditing section to, and what we strive for is more consistency with your billings, more consistency in results, so as to eliminate some unnecessary stress. I believe somebody in the back had their arm.
There was a flow chart on the website how to bill and how each
Yes,
case was. So,
that is still there. That is still there. I'm looking at that just in case to tweak it to make it more user-friendly. So those are things that I'm doing right now.
Right.
Yeah.
Like we had a flow chart on the website, and this is one of my favorite stories. It would call Attorney Billing Made Easy. And if you saw it, it looked like, so, it didn't make, fine, all right. So I take it over to the legislature, and the legislative members are looking at it, and they're doing like this. And I thought, when I got back to the office, we need to change the name of that flow chart, okay? Take the made easy off of it, right? Because it was just all over the place. All right. Any other questions?
I have a question.
Yes.
So you said that you're governed by the statute.
Yes.
And I've had this happen now a couple of times in Miami, so we have a high volume.
I'll repeat it.
Um,
Okay, here, let me give you the mic.
I've had this issue happen quite frequently. I'm on a TPR case where the mother filed a TPR against the father and the father filed a TPR against the mother. And the JAC's position is that I can't do anything to affirmatively move my client's case forward, and I can only defend it. But I can't find any basis in the statute for why I can't advance my client's case. My client's entitled to counsel. She's indigent.
Okay, so
It's a
repeat
private
the first
petition. The mother filed a private petition for a TPR.
Okay.
Okay, and this has happened now a couple times where I've got a private petition. And JAC's position is I can't do anything affirmatively. I can only defend. And I can't find anything in the statute.
Because you're not appointed.
No, I'm court appointed.
But
I'm court appointed.
okay,
because
you're
in this
court appointed
case,
to represent the mom.
yes,
but
in this case there's cross There's cross.
Okay.
Mom filed against dad, dad filed against mom.
Okay.
But I can't find anything in the statute, 27-511, only limits payment for civil cases, not for private cases in dependency. And the JAC's position is, I'm not going to get paid if I help, even though I'm court appointed, if I affirmatively move my client's case forward.
Because the client decided to file a private.
Correct. And if it's a dependency case or a TPR case, the statute's clear, she's entitled to counsel. Why can't I be paid for it? And there's nothing in the statute that governs payment to court-appointed counsel that sets that limitation. It's a limitation that you all set.
Okay. Let's talk offline about that specific situation. Because I will have to look at some documents.
Are there any other questions? Yes?
Well, if you mentioned the current contract, of course, I think there are a lot of us who are wondering if you have any updates on our current contract.
You know, I knew I was going to get that question out. So what I did is, about 20 minutes ago, I checked to see right now, luckily, we were able to persuade the legislature to give us $15.6 million in supplemental funding so that we could cover this year's need. So that what happened to us last year, which was basically we asked for $8 million, they gave us $5. So July 1st, we're $8 million in the hole. Just, first day of the fiscal year. So they actually funded us, and that was approved by the legislature on May 4th, all right? As of 15 minutes before this presentation started, that bill has still not yet been presented to the governor. Once this bill is presented to the governor, by law, he has 15 days to either sign it, veto it, or do nothing. All right, so it's not until that time frame. So every day, at the beginning of the day and at the end of the day, several people at JAC are checking for when is the legislature going to present that bill, which is Senate Bill 2500. It is the General Appropriations Act. That's where these funds are right now in limbo. Once the governor signs it, those funds should hit within a day or two. We negotiated and coordinated with the Department of Financial Services. We continue to process your bills, so keep sending them. We are processing them, we are approving them, we are uploading them, and DFS is auditing them even before the funds are there. So that way, when the funds hit, a great swath of them will be paid at one time. All right? That's the goal.
We don't know when that's being presented?
Exactly. Exactly. And we did some calculations based on the dates that the General Appropriations Bill was presented to the governor in the last 5 years. And we're beyond that. We had figured that based on what had happened the last 4 or 5 years, granted it was a different governor. We have a new governor who is currently out of the country at the moment. But nonetheless, we're very data driven, and we're constantly looking to see, because what we really do want to do is pay you. We don't get to keep any money we don't use, and it's not like the legislature is very happy when agencies revert money. If you revert money back to the legislature for failing to use it because you predicted incorrectly, guess what happens next year? They give you less. And that's, we've experienced an increase in volume in the last 5 years, an increase in several lines of business, and the bills that we have, I think when I first got there back in 2011, we were approving about just a little bit over 50,000 bills. Last year we approved 68,000 bills, and the average bill is larger. So, just follow that logic. So we have truly no win in trying not to pay you. Our goal is to process your billing so that when it gets to DFS, they audit them. If the bill's over 10,000, they'll audit. They also do random audits. If they start an audit on your bill, it's going to take a while. Yes, sir.
Two things. One, you said earlier that you're continuing to process our bills until they're approved and just waiting for DFS. But I've had stuff that's been in a pending payment status online since April 15th or 16th. All right, I'm not ever seeing it say approved, and that's the last step I usually see at JAC before it then goes to DFS. So are you actually approving them? And if so, why would somebody's billing be a month and a half before being approved after being pending?
They will remain pending until, right now they are uploaded into a queue, which DFS has access to, and they can pre-audit them even before the funds are there, but it's not going to say approved until they all go over there.
My understanding is that those things will be approved in the order that they came in and processed in the order that they came in, all the billings.
That is correct.
If things are already in a pending stage, upon the governor signing the bill, how long do you anticipate it'll be for your office to go through and approve each of those items?
No.
And are they going to be approved in sequence?
They have been approved already. They are in a queue. Since this is such an anomalous situation, this is nothing we've ever done before. And furthermore, what we were able to coordinate with DFS is also fairly novel. Okay? So they are approved in a queue. And as soon, and DFS is pre-auditing them, despite the fact that they don't have the funds yet. And once the bill is signed, I anticipate that within 48 hours, these bills will start processing. People who have electronic funds transfers, their payment is done by electronic funds transfer, EFT, which is actually required by law. They will get their money before anyone else. People whose EFT is not active or has fallen out, then that happens. If you haven't received payment from the state of Florida in over 6 months, your EFT will fall out of DFS's system, something we have no control over. Then a paper check will be cut for you, and that might take a little longer.
I appreciate the work that you at JAC might have been doing to try to make sure that we had a larger budget for this stuff and be able to make up for the shortfall this year. However, somebody in the legislature, according to all the legislative comments, if you go to the Senate website and also in the Tallahassee Democrat, it was reported, seems to think that this will have the greatest impact on court reporters and investigators who rely almost entirely on court-appointed work, whereas some of us attorneys rely almost entirely on court-appointed work. And, you know, it's really tough to go almost 2 months without any pay, especially when the Friday beforehand I signed a contract to buy a house, you know, and that has gravely impacted that. So, you know, I don't mean to sound frustrated, but...
You have every right to be frustrated. And it's examples like that that we used in lobbying the legislator, not for the court reporters, not for the investigators, but for the persons who are in court actually defending these cases. I mean, the last thing the payment process wants to do, I mean, to me, good administration is invisible. If administration is the headline, you're not doing your job. The people who are defending the cases and prosecuting the cases, they have the front lines. So this has been extraordinarily frustrating for us. And we sounded the alarm last year before the legislature closed and had been told all throughout the entire legislative process, do not worry. And because our treatment with legislative staff had always been so formidable, we had no reason to doubt that. But
Do we have any idea when Senate Bill 2500 is going to actually be presented to the governor?
that is the...
When it gets back, and it's really going to be another 2 weeks before it's even presented?
I have no answer to that. That is the $164,000 question.
I'd like to be able to eat and feed my kids.
I understand.
There's,
Yes, sir.
the governor's website has a place to make comments to the governor. That might be a better place to send these comments to. Why the governor kind of
Right. Okay. Yes, ma'am.
So when you talk about lobbying, does the JAC have an in-house lobbyist or do you use a contract lobbyist to help with these issues?
Do we have an in-house lobbyist?
Do you have a legislative
Mr. Colvin, who is the executive director, and myself are the lobbyists for JAC. Prior to this year, we typically met with legislative staff, and that was sufficient. This year, when we saw the way, no, we met with everybody. We met with every appropriations committee member. We met with the chairs of the committee members. We met with legislative staff. We met with OSCA. We met with all the chief judges throughout the state so that they would know that this was something coming to a theater near you, so that way they would know how to react to it when it occurred. We made a presentation last year at the Florida Association of Criminal Defense Lawyers, FACTL, basically highlighting this is coming. You need to speak to your legislators. You need to apprise them of this. This is a problem that has quite a bit of repercussions. It could have an effect on jails. It could have an effect on local communities. Just like Ms. Ellis was talking this morning, these things don't happen in a vacuum, and the consequences are far and wide.
Just so you're aware, and other people in the room aware too, that I asked that question, and I know the governor had a website, I think, Constitute, but you are the lobbyists, and you guys have been in process, so, maybe you get part to the legislature next year, but this actually has a direct, real impact on many attorneys out there.
Yes, it does. Yes, it does. Many attorneys and the state of Florida's ability to deliver judicial services, which bears directly on the public trust in government. Yes, ma'am.
And again, this is just to actually expand on his, which is not only is it attorneys that aren't getting paid, it is our experts that we're required to do. We can't go to our courts and say we're not showing up, we'll be thrown in contempt. However, we do have experts right now that are not working on our cases, so that we're still required to have a criminal defense trial, often very intense trials that we're required to participate in and to do the best things that we can to be defending our clients, but our experts aren't able to be participating right now.
Yes, we are well aware of that. There have been several motions filed throughout the state, especially in death penalty cases, where actually the style of the motions have been motion to strike the trial date for JAC's failure for JAC's lack of funding and failure and inability to pay for bills. Trust me, we are well aware. Unfortunately, I am the messenger here. And we are considering taking a different tack next year in our lobbying efforts. As a matter of fact, Mr. Colvin and myself earned the nicknames Doom and Gloom this year during legislative session. So when they would see us walking the halls, they'd go, ooh, here comes Doom and Gloom. They're going to be asking you for a lot of money. And when you think of it, when you think of Florida's budget, $15.6 million is really just like a drop in the bucket. So I do not wish to bite the hand that feeds me, but we are doing our best. We are doing our best, and we do sincerely make a great effort to be as transparent and as accountable to you, as well as to the judges, as well as to the state of Florida and the state taxpayers, because we recognize that we're paying these bills with other people's money, namely yours. Now, I do not want to short Ms. Davis of her time, because her presentation is far more interesting, okay? It truly is. It truly is. Once we get funded, it will be a lot more interesting, all right? So I'm going to get over here taking out whatever questions you ask, so that way if we're not addressing it on our website, we go too short. Thank you.
Now I will get into the nuts and bolts and overview of how to bill through JAC, which some of you are very much familiar with. I am Alicia Davis. I was formerly Assistant General Counsel. Some of you have had hearings with me on the phone. I'm the box on the phone, and some of you have emailed me about different billings. You can still do that. So billing for court-appointed attorney fees and dependency. As I mentioned earlier, majority of the bills we receive for dependency is flat fee billing. There is also the option for hourly billing as well. How are attorney fees paid? The flat fee. So there are certain requirements that is required in order to bill a flat fee in a dependency case. 96% of the flat fees, of the billings we receive, are flat fee. So the first step is that an attorney, once you have set up got your contract signed, have your My JAC login, an attorney will submit the JAC invoice and voucher cover. That voucher cover is available on our website. We ask that you please use the current voucher cover, as we are always trying to update it in accordance with the law. We also ask that you fill out completely and sign that voucher cover, because if not, it will delay processing of your billing. Once you have submitted that, as well as a dispositional document, for dependency stage of a case, the dispositional document will be the order on adjudication and disposition. I recognize that in some circuits that there are two separate orders. Just a little bit about myself. I am a former Children Legal Services attorney. So I am very familiar with the dependency system. If you have two separate orders in that circuit, the language that we look for is that the child has been adjudicated and that a case plan has been ordered as to your parent. So when you are submitting the orders, please ensure that language is in there. If it is not, the voucher will likely be rejected, and then it will delay processing of your billing.
Is it a case plan to just one parent?
No, your parent. So we look to see, I'm sorry. Then the question is, we will wonder, why are you appointed to the case to represent that parent? Okay, I understand. I've been in the circuit where the court will appoint attorneys to parents that have no allegations. In that case, then we would have to have a separate conversation, because we look to see, well, what type of services are you providing? What kind of advocacy if the parent has no allegations? I recognize that courts will appoint attorneys to parents with no allegations.
One of those allegations are not, those parents need a lot of representation.
I understand. I'm sorry. It's like three people talking. Okay.
That's a 6-day trial
With a non-defendant parent.
the non-offending parent's representation is just an actor. It's common wisdom in the 13th.
Yes.
It's really common to appoint a non-offending parent.
I recognize that there's an appointment. It's just, in terms of our policies and procedures, we ask, this is the language that we look for in the disposition document when we're auditing a bill. That is just what's laid out for us. That is what I'm relaying.
So perhaps we would change the language to make it a parent instead of your client.
Okay.
Because we do have 10 circuits,
Mhm.
just like what he was saying,
Mhm.
he said 13. We have it where we are appointed to non-offending parents, oftentimes because they finally found dad. for
Right.
example, And he's in California. He's not going to come back from California.
So somebody has to stand there
Somebody has to be there.
and speak for him.
Absolutely.
Thank you. I will take that into consideration. Thank you. So once you have submitted that document through My JAC, and if there are no issues, then the billing will be approved for payment. If there are issues, then you will receive an audit deficiency notice to your email that was through the contract. We're asked that whatever is in the audit deficiency notice, whatever issue, please respond and send that information through My JAC portal. If there are no issues, the bill will be processed. If there are issues, we may send another audit deficiency, or you may get a lot of objection. Whatever the issue is, if you need to contact JAC, please do. In some instances, we will send a letter of objection. That is very rare for flat fee billings. It's more common in hourly billings, considering that we have to have a hearing as statute has required.
Ms. Davis?
Yes.
Now that you're heading up court-appointed auditing, is there any way that we can reach out when we get an audit letter, a deficiency letter, to contact the auditor? Because so what happens is when you get the audit deficiency letter, there's a delay now with getting paid, and now you have to spend additional time, and sometimes the auditor just makes a mistake. And there seems like there's no way to easily correct it. And for those of us who just do dependency, it just adds, the more administrative tasks that we don't get compensated for, basically the less money we're really making on a case. So it's just you're adding to the work that we have to do. So is there any way that we could reach out to the auditor if it's something simple like they've made a basic mistake as opposed to going through help?
I do not encourage contacting the individual auditor. If you have an issue, contact me. I've given my cards out to several of you. Several of you have my email address. I would prefer you do that. In terms of our objections to administrative tasks, I'm going to be quite honest that we will likely object.
No, what I'm saying is in general, we're not compensated. It's quite clear in the contract, we're not to be compensated for administrative tasks, and even for considered ministerial tasks like reviewing a notice of hearing.
Yes.
Right? We don't get compensated for that.
Yes.
What I'm saying is, the more of that there is in a case, then the actual...
Yeah, the billing is going to be less.
Yeah, the attorney's actually making less for the time that he or she spends in the case, because most of the attorneys that do this don't have a large staff.
Right.
Helping them with
Right.
administrative tasks.
And my response is that will likely not change. Now, as you know, we've been in hearings. We will put that on the letter of objection, and the judge may overrule us. So
All I'm saying is just make it easier.
make it easier. Yes. Yes. I will consider it. I don't know if that can be changed, what you're requesting. But I will consider it. Just in the future, you go to an evidentiary hearing, you make your argument. These hearings do not last 30, 40 minutes. It's particularly in your circuit. So it's likely going to stay the same in that regard. Just honest. We're not trying to make it hard, but statute requires us to provide meaningful audits. And so that's what we're tasked with. So we have to do what statute.
Right, but if they make a mistake, the auditor makes a mistake.
If a mistake, then you contact me. If it's a miss, and you have emailed me before, and we have talked, and it's been corrected. So as I will encourage the same thing. Like I said, we're not here to make it difficult. At least I know I'm not here to make it difficult. So in terms of, you have any other questions in regards, any other questions? How our attorneys are paid hourly. So if you want to, it's governed by statute 27.5304 subsection 12. There are several requirements. The attorney must submit the JAC voucher cover, the hourly invoice, the dispositional document, and the court docket. That is because we are going through the docket and looking and lining up your entries on your hourly bills. Yes.
So I always get the docket
Mhm.
from the clerk, but we have access to the attorney of record docket. Can we submit that docket? Because that's actually, I can download that on my computer.
And does that docket include like all the hearings in the case, all the filings that was done in the case?
It does, but it's a little different because the clerk's docket, I noticed it says hearing, where ours just says.
Is it a little bit more detailed?
It's just set up a little bit differently. On the bottom, it's all the hearing stuff.
Okay. If you can, that may be appropriate. I will have to see what that looks like because every circuit is different. Does it look like, I don't know if you have access to CCIS. Is it similar?
It's like exactly like the docket, but.
Okay.
It's in it, like if you would go on a family law docket, something like that, when you go online and you do your family, it's the attorney of record docket. It's just that I don't need to get it from the court.
Right, and you could just use yours. It sounds like it may be appropriate. I would like to see an example just so we don't have to go through the trouble of a rejected voucher because to delay your billings.
I have a question, does that docket have more or less information than the court
It
docket?
basically has exactly the same information, but I did notice that the clerk's document, Odyssey, which I don't know why we have access to, says, hearing, like a trial, whereas ours doesn't have that. It says it at the bottom.
The submission of the court document is not,
The submission of the court docket is not in lieu of the timesheet. It is just something for us to compare the timesheet against. All right, and we use that and other things as well. So I would submit whichever had the most information. because that would support your billing more directly.
But it would be easier, I guess, for you to get the attorney docket than. Okay. And I can look at that to see if it's appropriate. I think there was a question over here. Saw him.
My biggest beef is when, we're substituted in for an attorney who's withdrawn, which is usually after they've milked the case and done dispatch. And so I'm on it, and I've got my lawyer, appointing me as substitute counsel. So then we go to the first JR, and then I submit my $200 bill to JAC, and then they reject it. And
After you've been
to say, tell them we're entitled to our $200. I don't need to get a fee waiver from the previous attorney, which is who knows where. That is such a beef with me. I think other attorneys were like, for our begging for the $200, we've got to do $200 worth of administrative work just to get paid for that. If they can
So they substitute. So you're substituted in. The attorney's in the. You haven't heard from the other attorney.
Oh, I forgot to tell about another attorney, even though I know we're supposed to, but go ahead.
Oh, okay. So you don't hear from the other attorney. You submit your $200 bill, and it's on hold. It's rejected. Is there language in the rejection?
It's asking for the signed waiver from the.
Oh, from the previous attorney for.
And we've got tons of their cases, like.
Yes.
Different cases from people that have died or been disbarred. Yep. And it's their law, and we can't get a fee waiver from them. It's suspended, and we can't contact them. No, we're supposed to get.
Right.
$200 after the first JR we appear on, and it's rejected automatically every time. And they're like, you've not been able to hear. I'm like, that's not what your own chart says. Or
Okay.
you need a fee waiver signed from a dead person.
Okay.
I'm like, they're dead.
Okay. Okay.
And then it takes weeks and multiple emails, and to have a city own chart, it should not be something that we have to do.
So if you can train the people who are processing it, you're going to ban in this situation. Because once I send an email,
Who are you sending your emails to?
the help desk pay it,
Who are you sending you're sending your emails to the help desk?
An email to
Right.
Christian
Oh, Christian Lake.
The help desk won't do anything. I sent an email to Christian, he tells them to pay. But it's every single time it's rejected, and
Oh, wow.
there's supposed to be a time for that.
Okay. I understand the frustration. And I am taking note of it. Okay. You shouldn't have to jump through hoops and then send an email and then they say pay it if we're just going to process it for payment. So I will take that in consideration. I apologize you're getting rejection notices in situations that an attorney is deceased, disbarred, suspended.
Well, we shouldn't have to get a fee waiver anyway, because, we're entitled to the $200.
Right, and that's why I was.
Well, I've done that before, and you have to wait a month to get them to sign it. But we shouldn't even.
Yeah, because you are entitled to the $200.
Anyway, after the first JR we appear.
Right.
So they shouldn't be rejecting it.
Okay.
I believe part of the problem there is the statute. The statute says that when there are more than two attorneys, they cannot get paid more than the necessary fee. So it requires a hearing before the court. I've had this issue before where the attorney did in fact pass away, and we had to have an evidentiary hearing, and the judge had to take judicial notice of that fact in order so that the subsequent attorney could get paid the fee that they were requesting.
Except that I've been told by JAC, this is the counsel before, that it's JAC's position that the new attorney's entitled to $200 fee, regardless, once the other attorney is off, once you get your first JR, you can bill that at $200, even if it hasn't been a year, and it's regardless of whether or not there's a fee waiver or, and I've never had a hearing on it. I've just had somebody know.
All right, well, you point out an inconsistency, and when we get back to the office, we will look at it and deal with it. But thank you for that. We appreciate.
You guys can think about how much work we do when we come in, and we're taking over, we can file motions, attend multiple hearings, we're only asking for $200 for the whole next year. So that's, and then we have other people that, bill hourly and have to know the system, and we're just asking for $200 for an entire year's work, and we have to fight for it. And so that's why I think there's some frustration.
I understand, but our task is to audit them and to make sure that there are meaningful audits, and that's how we're assessed, you know, of how good of a steward are we. So we understand the frustration that it's causing you, and you know, we will look at the issue and see if we have any discretion. But if we don't, we have to abide by the statute. We don't, if the statute says one thing, we cannot do otherwise. And I understand that it's frustrating. And this is not the first time I've come up against this. I've come up against this very similar situation in many different scenarios, not just dependency, but in criminal and in capital collateral cases. I get it. I used to be a private lawyer. I've worked for the state. I've kept my time. I wholly understand it. I've also had private clients that wouldn't pay me for the time that I spent on a motion for summary judgment, despite, you know, how successful it was. So I understand, I get it. So we will see and make sure that we are acting within, you know, the limits of our means. And if there's any way to accommodate you that we can do so legally, we will do so. But if we cannot, I hope you would understand as well. Okay? Yes, sir.
I know that you lobby for the budget that you anticipate that you need, and you're not lobbyists for us as private attorneys. But just in that effort that you have done, are you aware of whether or not the legislature, or can you tell us whether or not the legislature is aware that on some of these cases like this $200 yearly fee that we get for dependency cases? I think that's probably structured under the same statute that says you have to have a judicial review at least once every 6 months. And when they figured the amount that was necessary to cover that, they figured $200 to go to judicial review. But I don't know of any circuit that I've practiced in where that's all you have. You have dozens of judicial reviews. Not dozens. You have statuses, judicial reviews. You may go to court 5 to 6 times in a year on something you only get paid $200.
You may find it might be good for you to know that part of the General Appropriations Bill contains proviso language for a study to be conducted this summer on the court-appointed compensation structure and the different practical issues that arise through it. And your voice, the voice of the actual, you know, participants in the system, would be very welcome in that. Because if not, if you don't have a seat at the table, the people that are going to make the decisions are not going to hear this voice. So, and likewise, as far as updates, the moment Senate Bill 2500 is sent to the governor's office, we will issue a press release. And the moment the governor signs the bill, we will issue a press release. And the moment the first bill is, you know, sent out, we will issue a press release. All right? So truly, there's plenty of people at JAC watching this very carefully, and we already have press releases prepared. All we have to do is post. All right? So just stay tuned. Alicia, back to you. Sorry.
No, you're okay. Any other questions? Comments? I do want to make note that there has been a change to statute that requires that you give at least 20 business days notice for your hearings. That includes attorney fees, as well as if you're requesting a due process provider and we have objected or we have requested to appear any notice of hearing. It used to be at least 5 days. It has now been changed to 20. I'm sorry. That I think that statute was just been signed. It's not. I was told that it was.
Oh, really? Okay. Okay, I'll pull it up.
Please. Because I was told that was coming up. And to make that known.
Okay, why would they be 20 days? Who would initiate something?
My understanding is that the 20-day hearing, notice hearing is only for extraordinary fee bills.
That's a lot of time.
I think. And you'll send it like within like a day or 2 days because you just got on the.
Yeah, it's extremely difficult. I find the JAC very easy to work with. I'm wondering why would they.
This was passed by the legislature. It's nothing that we.
Right, we didn't ask.
Legislature.
I have no answer to your question. I was surprised to find out that my reading of it is that it only applies to
Extraordinary.
Okay.
Not due process.
Access due processors,
Okay.
which might be a little bit more time. It would be even more time sensitive.
Okay. So how do your due process vendors get paid? So due process vendors typically in dependency cases are your medical doctors, investigators, court reporters, neuropsychologists. They too can have their bills processed through JAC. If they do want to be paid directly, they must sign a contract with JAC as well. And their contract will be the Type 1 and Type 2 contract. Type 1 is for your investigators, your court reporters, transcription services. Your Type 2 is for your medical doctors, your neuropsychologists. And then I believe Type 1 is also for your out-of-state vendors, because in some cases, especially like in the Panhandle, you're so close to Alabama, you're so close to Georgia, you may find vendors in those states as well. So the first thing that needs to be done, because we are not with you as you are seeing these due process service vendors doing their services on your case, we are asking that when they submit a bill, that if they want to be paid directly, that you actually review their bills, ensure that they are true and accurate, because we are not with you guys in the courtrooms, in the fields, prosecuting and defending these cases. So what you would do is go on the My JAC portal, you will open a new case, ensure that it's not for the indigent for cost cases. This will be the new case submission form. You will submit your order of appointment. Dependency, we do not require the petition for dependency or the TPR petition. And we please ask that you do not submit that, because we do get public records requests. And there's a lot of sensitive information in those documents. So all you guys need is to upload your order of appointment. Charging document is for the criminal cases. We do require a charging document to open a case in criminal billings. At that time, you would serve your motion for costs on JAC. Typically, we ask that the email kind of sort of looks like this. You would send it to pleadings@justiceadmin.org. We request that you put the case number in the heading and just a generic motion for an investigator, motion for a medical doctor, motion for a neuropsychologist on your case. And make sure you attach the motion. We also ask that you attach your proposed order as well. Typically, we do not object to these appointments. We recognize that due process is a part of your cases. So you will typically get an informal response from JAC. So we ask that you just attach the proposed order as well to make it easier so you can go ahead and get it signed with the court. This is what the informal response looked like. Many of you have probably seen this. If you have requested due process service vendors, you will get the JAC takes no position, will not be filing a formal response. Once you get that, we request that you add that to your motion. Statute requires that the court considers JAC responses when they want to appoint a due process service vendor. So please make sure you attach the email so it'll save the time for the judge asking, what does JAC say? Do I need to get JAC on the phone? If you attach it, he can, I know in some circuits they sign it in chambers. If you need a copy of model motions and orders, that is available on our website. We don't want to have to recreate the wheel. You can download those in PDF or Word form for your cases. Motions, must-haves. For due process services, there are only there are certain circumstances where there are statewide rates. So JAC did not set that rate. The legislature set that rate. For investigators, a C-licensed investigator, the rate is $40. It is no less, no more than $40. That's the most they can get. If it's an investigative intern, it's $24. No more, no less. JAC does not advocate. We do not set that rate. Court reporters is the same way. They have a statewide rate that they must follow. Other than that, there are different rates in different circuits. Every circuit is different. JAC has the rates for all the circuits on our website, so you can look in that particular circuit and see how much it is for process services if you need to serve someone. Experts the same way. Every circuit has a different rate for their medical doctors, their interpreters. So please make sure you are including the rate and the cap. If you've ever been in a hearing with me in terms, I'm always making sure that the judge puts a cap. As you can see, there are not unlimited funds. So we need a cap, whatever the court deems appropriate in that case, whether it's $1,500, $2,000 for that particular case. If the expert or due process service vendor exceeds that cap, you can go before the court and request more funds. For motion for attorney fees, we add specifically for hourly that you include your requested amount and the language that says that is the case extraordinary and unusual. Heurily billing is only championed for cases where the case is extraordinary and unusual. And in that evidentiary hearing, that we spoke about earlier, that is what you're going into court to advocate to the judge. How is this case different from all your other dependency cases that make it extraordinary and unusual? I typically, in the cases that I have done, the attorneys will come in and talk about the complexity of the case. Does the child have special needs? Did they have to go to IEP hearings? Did they have to go to staffings with this individual, that individual? Is there the number of children on the case? Right. I mean, I've had AALs bill hourly. Yes. And their bills are typically not your standard. There's a lot of hearings. There's a lot of out of court work. And the rate for that is $75 an hour. That is set by the legislature. So in an evidentiary hearing, I have always encouraged that in your written motion, outline how it's unusual and extraordinary. So your judge can already have an idea of what the case is about before you get up there.
Can you start with I'm sorry. Can you start with the flat fee and then go into an hourly?
Yes. I've had attorneys that bill a flat fee and then they'll recognize that, okay, this case is you're right. It is taking on a life of its own. Flat fee is just not going to compensate me for the work that I'm doing. So I'm going to bill hourly. But know in billing hourly that you have to keep your records. You have to bill in temps. You must bill for the time that you spend, not estimated, what you actually did. And you keep contemporaneous records. So and you have to, and your contract says you keep those records for 5 years. So in case you have to do an inspection or we have to do an audit. So it's a little bit more time consuming than a flat fee. But what will happen is in those cases is that when it's time to bill your hourly, we will offset the flat fee that you received before. So if you bill us for $2,500 and you previously got an $800, we will subtract that from the $2,500, and then you will set your fee hearing.
So do we go back to the beginning for the hourly?
Yes, you start from the day you were the day you started the services. That's why it sometimes is you have to guesstimate because the cases take a life on their own. But you have to recall the work you did at that time and put it on your hour, and it's difficult, but attorneys do it. I mean, some just outright start keeping their time because they just never know where that case is gonna go. They just go in keeping their records. I'll get you.
AALs are not on the special needs AAL.
Okay.
And this happens in those.
Yeah, just.
I think the majority of the people who do AALs, let's say 20% are special needs.
Okay.
They're basically
Just appointed.
Which is the point. They're not compensated monetarily. They're voluntary. They're not part of what's covered under the statute.
An attorney appointed to represent a child in a dependency case. Oh, you take it pro bono. Yeah, we don't pay those fees, but right. Yes, that's the end of my, yes.
Let's get back in this week down in
Uh-huh.
I have to go see them.
Yeah.
In a couple months.
Yeah.
Are all those costs just billed the same month?
Yes. The end of my presentation, I talk about that and how you get access to your costs, your travel costs. I talk about that. So I will get into that. But yes, you do get access to that cost. In terms of travel, you have to get it pre-authorized from the court. So in that case, if you know you have a child in homestead, you will request the court cover it. Yeah.
Is that for the special needs kids too? I gotta get pre-approval from the court for mine?
For travel and mileage, yes, if the child is outside.
And a lot of them are, they're all.
Yeah, they're all over. They're in treatment facilities,
So,
nursing
I think
facilities.
the court order
Yes, that is what we prefer.
that y'all are to pay the mileage?
Yes, get a court order that authorizes travel. I don't, we,
Oh, that authorizes the.
right, that you travel, because you know that you're gonna be,
That's interesting, because they expect me to go see them right away.
right. I mean, it's as close as you can. I'm just anticipating that you don't get a rejection or audit deficiency. I'm just thinking about when it's time to bill. Just to save you time. Outright get it and upload it and send it to JAC. So it'll save you time for your bill to be processed.
That's on the new process for the pro bono attorney.
And for court appointed.
And for the special needs.
It's,
But if you're appointed directly and you're being paid,
Mhm.
attorney ad litem or attorney for the child with special needs, and you have to travel, I thought
Yeah.
that generally speaking, you could put your mileage was over a certain amount anyway. without
Yes,
getting-
over 50
without
miles.
getting pre-approval of the
Yeah,
court.
see, I've gotten paid without pre-approval.
that has,
I had a hard time, because I said I got to go see my kid in Jacksonville for damn.
right.
And they paid it, so.
It has been approved in the past, just best practices. That is the suggestion. I understand that it's been approved. And if it's over 50 miles, it's understood that you're gonna be traveling.
And it's gotta be over 50 miles one way.
One way, right.
Like if I'm in Polk County.
Right.
And I go to Daytona to see
Yes.
the child.
Mhm.
You know.
Yes, I'm just giving best practices to prevent you getting an audit deficiency, to prevent you from getting a rejection notices. I just want to, in advance, just,
And that's the tolls too, I think they pay the tolls.
yeah, it covered that as well, I believe. I'm gonna get you. I didn't forget. I think you had a question.
Well, my question was just, with those hourly bills of the AAL,
Mhm.
the end of the case.
Well, I've had attorneys bill interim, not so much at the end of the case. There have been attorneys that, if you especially have an older case, well, they want to have, they need to get paid. So,
Because, for instance, like with a child who goes into extended foster care and the case stays open until
Yeah.
they're like 22, 23,
mhm.
I guess, how do you know whether you should wait until when they turn 23 or?
It just depends on your personal preference. Like I said, with interim billing, I've had attorneys where what they would do is they will bill interim and you will receive 80% of your fee, and then 20% will be set off to the end of the case. And that will be so. What you would do is you would send in the bill. We'll check and make sure the case has not closed. So we'll recognize it's an interim billing. So your letter of objection will have just a portion of it that will say, you have billed interim. You are entitled to 80% of your fee. 20% will be carried forward to the end of the bill. So it really just depends on if you want to bill now or if you want to bill at the end, because those cases do last a long time.
Is it true that once you go to hourly billing for the rest of the case, you gotta stay on hourly?
Yes.
You can't go back to flat?
Correct. Once you shift to hourly, that is the way you have to bill the case from that point. Any other questions?
I have a question about the, if we're going to be required, we need to go and see a client we've never seen before.
Mhm.
And we want to know if there's time to give the hourly bill knowledge to get it first.
Wait,
You still have to reject the statutory, you have to reject.
but yes, still bill for the time you meet with your client. Yes, and make sure you put the date. If you want to put, make sure you consider your privilege and make sure you're not including information. Because like I said, we get public records requests. So make sure there's nothing in there that needs to be redacted. But yes, bill for that time that you speak with your client. Like I said, many times you don't know the life of the case. You don't know. You may start out flat fee and then realize that I need to bill hourly. So like I said, some attorneys, they outright start keeping their records and their time from the outset. So once you have received a response, you file your motion with the court. The due process service vendor goes out, do their services. Now it's time to submit their invoice. when they have submitted their invoice, if they're going to be paid directly by JAC, you will see on your profile their invoice is waiting for your review, because we require them to sign it as well as you to sign it as well as the attorney who has requested them. And at that time, you will wait, it's audited, then it's uploaded to Flare, and then payment is issued. Okay, any questions? I'm trying to run through because I know we're a little late. Okay, pro bono attorneys and due process costs. So access and due process costs for children with special needs. At this time, mentioned earlier, the statute was amended in March 2018 to allow pro bono attorneys access to due process costs when representing children with special needs. In order to get access to due process costs, you as the attorney will execute the IFC contract. That's the indigent for cost contract. Once you have executed that, you will draft a motion to declare a child partially indigent, which is available on our website, so you don't have to recreate that motion. We have already drafted that motion for you. And then you will get a signed order finding the child partially indigent. Please make sure in that signed order that you identify what special need the child has. That is required for that order. Once you get that, you will email that to pleadings@justiceadmin.org, and then your due process service provider can start submitting their billings in that case. So that is an amendment that happened in 2018, because before that, that was not the case for pro bono attorneys.
And just to verify, they have to be special needs?
Yes, they have to be special needs. Right, is it not special needs? Can you get due process costs? No.
That is correct.
Yeah, that's the only statute of authority we have.
Basically funding this volunteer.
I didn't get the law changed.
Yeah, we got to get the law changed. Yeah. At this time, we don't have any statutory authority.
We are only authorized to pay bills for persons representing indigent clients who have a constitutional or statutory right to state-funded costs. And we can't go beyond that. We can't make those discretionary calls. That's up to the legislature. So if that is a large part of your practice, and if that's part of your practice,
Some people think of these as well. We often get appointed, and this should get certain students as well. We often get appointed as an attorney ad litem for a child that doesn't technically qualify under any of this. Yeah, we're court appointed.
Oh, then in that case, due process costs.
Our pay.
They're not special needs though, like the order, only Hillsborough does it, by the way, after work and pass it on to Pinellas, and they absolutely cannot, so we won't get paid.
Court appointed as an attorney ad litem. Yes.
and the order of appointment says the court is appointing you to represent this, your.
Correct.
But they do not qualify for special needs.
Under the specific categories in the statute. Under 1305. What? Yeah, so you understand the question?
I understand.
Yeah, okay. And is there a...
Have you tried to submit a due process? You have not. Has anyone tried to?
I just thought it would be an automatic no, so I cannot say that I've
Tried, okay.
That's my question is, do we use the same process? We are court appointed as attorney ad litem, but it's not...
But it's not special needs.
It would be best if we followed the order of appointment.
Yeah.
No, we have to.
Of course you do, if you sent it to us.
Sure.
Yes.
That would be
That's-
very helpful.
Yes, because I wanted to know if you got a response in that. Right. Right.
Will you email us this slideshow or?
It's available on the app. We have emailed it to the GAL on the. Yeah. Mm-hmm.
Yes, however, if
But
you
you-
email us, we'll send it.
Right. Yes.
And just-
I have mine.
Just a quick update, the bill that requires a 20-day notice.
There's our
for
emails.
motions For extraordinary fees, that has not been presented to the governor yet, therefore it has not been approved yet. But it's still in there.
And So
Right, it doesn't fall
we're
in
talking
the,
about cases, we're talking about situations like that where children have been raped by their dad or stepdad or mom's boyfriend, and we're having egregious upfront trials, and we can't get costs. So just if that ever comes up, that's kind of the situations we're
Right.
talking about.
In years past, in the last 2 or 3 years, actually there wasn't one this year, but the 2 previous years before that, there have been attempts to broaden that statute and add a catch-all provision wherever the judge deems appropriate. And however, that has failed. That has failed, and I would suspect, given the fiscal realities of that and the inability, you cannot control what happens in court. If a defendant needs something, they need it because their constitutional rights must be protected. So given the nature of that, that's what I believe causes hesitation on behalf of the legislature to fund things open-endedly. But as a special needs statute is proof of, it can be obtained. It can be obtained, but it requires a consolidated lobbying effort and a sponsor or two. Okay? Any other questions? Thank you so much for being brave enough to attend our presentation. We truly are here to help, okay? Call us on it, okay? Thank you.